Sikshayati, platform for eminent authors, engaging teachers, successful students. To know more, email. General rules of delivery of goods. Delivery to carrier or Wharfinger, where goods are delivered to a carrier for the purpose of transmission to the goods or to a Wharfinger for safe custody of goods. Delivery of goods to them is deemed to be a delivery of the goods to the buyer. Rules of delivery to carrier. If the seller does not contract with the carrier or Wharfinger for safe custody of goods and the goods are destroyed, the seller becomes liable for such damages, or the buyer may repudiate the delivery to the carrier or Wharfinger as a delivery to himself. Where goods are sent by sea route by the seller, he should give a notice to the buyer to get the goods insured, otherwise the goods shall remain at the seller's risk during sea transit. Risk of goods during transit. When the seller agrees to deliver the goods at his own risk at a place other than where they are lying at the time of contract of sale, the buyer shall bear the risk of goods incidental to the course of transit. Delivery of goods in possession of a third party. If the goods are in the possession of a third party during sale of goods, the seller cannot deliver them to the buyer until such third party acknowledges to the buyer that he holds them on his behalf. The consent of third party is not required if the goods are sold by the issue or transfer of any document of title to goods. For example, railway receipt, bill of lading, etc. Place of delivery of goods. Where the place for delivery of goods has been specified in the contract of sale, the goods must be delivered at such specified place during business hours on a working day. If no place has been specified in the contract of sale, the delivery should be made as follows. Sale. In case of sale, the goods shall be delivered at the place where they are present at the time of sale. Agreement to sell. In case of agreement to sell, the goods shall be delivered at the place where they are present at the time of agreement to sell. Future goods. In case of future goods, the goods shall be delivered at the place where they will be produced or manufactured. Time of delivery of goods. If a certain time for delivery of goods has been specified in the contract of sale, the delivery must be made at such specified time. When there is no specified time for delivery of goods, the delivery should be made within a reasonable time. Reasonable time of delivery of goods. What is reasonable time is a question of fact. Unless specified or inferred otherwise, reasonable time means usual business hours. Sometimes few words like directly, without loss of time, forthwith are used in the contract of sales indicating immediate delivery of goods. In that case, demand or tender of delivery should be made at a reasonable hour. However, what is reasonable hour again is a question of fact. Express delivery. Unless specifically agreed otherwise, the seller is to bear expenses required to put the goods in a deliverable state, and all the expenses for obtaining the delivery of the goods, that is expenses of transportation, shall be borne by the buyer. Thank you for watching the video. Kindly write your comments. Click on the red subscribe button at the bottom of the video to get more details and free ebook. Email us.